State of Texas versus Katherine Welch. Ma'am, are you Katherine Welch? And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report? Are there any additions or corrections to that report? I'm going to get to that too in just a second. Any additions or corrections?
Here we go. Family members lining up with the emotional defense letters. If you've ever watched a sentencing hearing, you know this pattern. The defendant is an angel, a good boy, a never hurt a fly type, until the charges roll in like a freight train. And Judge Boyd, she's seen this play 1,000 times, and she is not buying this.
Okay. And Ms. Malfino has already stated, as well as I have received a sentencing memorandum at 5:47 p.m. yesterday. I'm going to point that out for the record. Well, it was reviewed quite early this morning, but I did review it. Ms. Malfino, you've had time to review it as well? Okay. Other than that, I think you all should have a couple. There's only a few, but there were some jail incident reports that should have been provided to counsel. Did you both receive those as well? Okay. Is everyone ready to proceed with sentencing then? All right. Mr. Gertz, do you have witnesses?
We have a person from the Dream Center. She's inquired about that. For students.
Okay.
Heal symptoms. Seriously heal powers. So, like something about, and sort of allowing the court size to forward to we are open as well to
Sure.
you know, it's just like it's going to be to those well.
Okay.
Working
Right.
This is where things get uncomfortable. Notice how every answer so far paints Troy as harmless. But the prosecution is about to start dropping the actual allegations. Weapon use, threats, violence. These are the moments where supportive testimony crashes headfirst into documented evidence. And the courtroom energy shifts fast.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to since I would need that, then I appreciate them being here and I'll ask questions. Ms. Malfino, does the state have any witnesses? All right, then argument.
Judge, I want to recognize the for some really small classes. I have personally treated the contract on over the last 3+ years, almost 40. As a project for me. And what I mean by that is, I know what the chance could this person do everything I ask for, wasting an opportunity in your review, actually before my asking. See bias by doing the ungated window. The LC is there, starting to explore with federal counselors who are staying on some of the underlying issues that might be on school protection process to do with her mental health and experience in her life. They tell me that court is in their opinions and are incredibly fanatic about it. I think she had repressed never really drunk in the form. And so the counselors have not just out there, but to outpatient program to address some of the trauma issues that she's having. She went into that program, stayed for basically And yeah, did everything we asked to do. When I told her to go get her own transaction, I told her to go get her own, get a lot of advice, to all of that, those records. When we're successful in following those we have. And we're going to the counsel actually reach out hundreds of direct degrees to try to figure out what she did do next. She should commit herself to her sobriety, the mental health issues that stem from the challenges that she faces as a young person. She you can look at one side of the ledger, the rap sheet or the history of who Dr. Fox this person. What I have unfortunately enough to do to really get down to understand her as a human and see that all the progress she's made, all the effort she's done, see what she's done well, and all the problems that she's done well. She's obviously anxious on the table for looking for to be able to present that. And I want to go down on the bottom to address what I saw in the process. He's not saying that this wasn't the work that came out of her mouth. She was asked by one of the examiners for probation report. She felt she needed treatment. She said she didn't feel like she needed treatment. She wasn't opposed to it. What clarifying to me by Dr. Sagers here, what she would say, I think, is she did counter those detox.
Pay attention to this. The witness admits she only knew some details, and then the prosecutor starts listing everything she didn't know. This is a tactic, undercut credibility without attacking the witness personally. It's surgical. It's clean. It's devastating.
In terms of going to a program that's specifically for currently using or currently responsible, she thought that was the direction. The idea of she will do whatever you want to explain what that comment means. And so, a lot of times, you know, Judge, I would feel as she programs will just reject clean for 3+ years. And she, and so they just wanted to simply off. So I think there's some miscommunication between the probation officer and Catherine. But nonetheless, she's willing to do whatever for she's just doing. Additionally, with her, we've been in contact with her current parole officer. They are willing to strong her, extend her on here, depending on what happens here. So that was encouraging as well. The same kinds of conversations with them, I probably about that. So that's encouraging. Signs on that. And then finally, Judge, you want to focus much on support for the kids who live in this rather than all things. It's different focus. She has family. She recognizes the impact that all of this has had on her relationships, training, her husband, both financially, also emotionally. She essentially fought God and is asking for to consider explain where you are positioned for asking the court. And obviously, she won't like her to be there, or she to be I'm not sure how to do this.
Okay, thank you. Ms. Malfina?
Judge, I'm not going to be in the position of the court then, Corey, that we figured seriously the comments Mr. Jones had taken on board and more vote. So those things, I'm sure it's difficult for me as a police of that county state citizen or on the right and to stand up and say I agree. Probation, yeah, just for Mr. Jones said probation way that their side of the coin and suggest that she give the benefit of the doubt already by the way the initial status. It should have been placed based on whatever prior should have said. We be cautious not to say, ignore all those crimes, absolutely not. But obviously, we have seen that for multiple trips intentionally, not resulting in no change to the locally in these last 2 years. I do sympathize with this Welch as an individual. Again, it's hard for me as attorney, this attorney to say that I with the punishment being formation that I don't, and disagree with comments that this is a challenge. We've had multiple conversations about this case. I have talked really diligently about it. I don't really know judge, and that's why it's before you that putting her in 20 years in Indiana versus the basic probation period where she can continue the charge and really better off. And don't know what it is about just the trouble safety and work realized. So I would just run to the courts with and thank you for the next comment.
All right, thank you. Anything else?
Your Honor, I just want to say that the past fueled by drugs and alcohol was responsible. That I did not know I was really young when things happened in my life that that it could have been someone who had been treated some earlier if I had gotten help for my mental health. Yeah, after I received DUI, that helped me get myself to a place that I could go into a treatment program and deal with some of those past traumas. In the past, I did have medicated and drank. Forget about the pain. Just know myself.
And the courtroom just got spicy. A spectator talks across the gallery. Major no-no. Court security treats this seriously because crosstalk with inmates is a safety issue. The judge shuts it down immediately. These little moments remind you, real courts aren't movies. One stray comment can stop everything.
I didn't know how to go deal with that. So when I got on my mental health meds, I had bipolar, PTSD, and my mind back then really chaotic. I was supposed to say after I had my mental health meds, I was able to go through treatment at Santa Maria in Houston, and I placed really a lot. Did extensive 90-day treatment with trauma counselors, trauma informed community care, and also I completed that. I worked in outpatient program, but I still lived on that facility. I went to the sex trafficking and recovery program, and I was in that for about 8 months. Where I got state paid for counseling for trauma still, and I just worked really hard on that. I got a job while I was in there, and then once my program was over, I moved to sobriety facility, and I found the spring, and I worked with so I felt like I was strong enough to come home and do what I needed to. And it was a complete program for 5 years. And I'm sorry, I'm very nervous today. And I know that my past record is like rapid function. But the things that I had to deal with within myself when I was a little girl, those are things that you don't go through. Even in your programs there that you don't talk about. You just don't. And I see you, please do not send me
back to prison. I know what I have before in my life, and this year that I'm in jail has given me more time to think, know that I am definitely headed in the right direction. I was sponsored. I can be at home. I should moved all of my life as far as I could with my sobriety. I knew this process out there. And I think I made some really good choices with my good county and good friends. It helped me a lot. And I am open to use some role about my rules. And do anything that's asked. And I think, I know now that I'm responsible and capable to care about in my life.
Thank you. So, Ms. Welch, this small fan, I probably said it yes, Beth. I get this often. They don't envy my position, and this is the worst part of my job. But I worked hard to get here, and it's my job. Part of my job, several things, and it's just to look at, obviously defendants and giving chances and things like that, but it also is about making our community safe. And I have to look back. This is your 10th DWI. It's not your 5th. It's not your 8th. It's the 10th. And while I understand the trauma that you went through, that you've been to safety 3 times. You've been given opportunities on probation where they were revoked. You've had opportunities while you were on parole to do what you have done now. And while I appreciate what you've done, and I think that's great, and my goal isn't to, to stop any improvement, but I can't, in my opinion, in good faith, go home tonight, look myself in the mirror, and say I gave somebody on their 10th DWI that your last sentence was for 15 years in prison. The one before that was for 10. The one before that, you've gone to another 10 years, back in 09. I mean, this goes back to the 90s. You got a 10-year sentence in 2011. While you're on parole for that one, you get another one, so they give you 15 years, and you get out and you're on parole and you do it again. The fact is, we're just lucky that you haven't killed someone in our community 9 times over. Being given opportunity. I just can't do it. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find and your plea true to the prior offense. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to sentence you to a term of 18 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. You're going to be handed a trial court certification that shows this was not. Well, I guess there was an agreement because the waiver of the enhancement, which could have been a 25 to life, as Mr. Gertz said. So I'm going to hand you the certification that shows this was an agreement. You've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read the written admonishment I provide you. If you have any questions about that, you can talk to Mr. Gertz. And Ms. Welch, I take no pleasure in this. This is extremely difficult for me. I understand, to some extent, addiction, and I understand that you are on a better path. However, there have been plenty of opportunities in the past where you were on a better path and you got back out and you got back on our road again. And so, good luck to you, ma'am. Thank you, Mr. Gertz and Ms. Malfino. Court will be adjourned.
This right here is a turning point. The defendant finally acknowledges responsibility, something judges look for. But notice what he blames: buttons pushed, manipulation, emotions. The judge will decide whether this is accountability or just another deflection dressed up as growth.